who have to sell their property with court confirmation. Don't settle for 1980s service. The market's too competitive. What do I mean by that? I've been in real estate since 1986. One thing I know is there's nothing good that happens once a buyer's offer is accepted, if you're the seller, until they close, you get your check. Everything is either a delay or worse, bad. And so as a seller in a court confirmation, we want the property, the escrow, to close as quickly as possible. What's that mean? I work with my attorneys to make sure that they have the order ready to go to drop off at the court the day of the confirmation. If there are changes that have to be made, to make them right away to get the offer submitted. If it's urgent, ask the judge to expedite the signature. Sometimes they'll do that. But what amazes me is the fact that attorneys will wait to deliver the final order and not know how important that is. See, the escrow date technically is 10 days after the buyer is given a copy, a certified copy of the judge's signed order. What does that mean? If the judge signs it in court that day, which they rarely do, and you gave them a certified copy on the spot, rarely does that happen, it'd be 10 days from that day. But if the judge, if the attorney takes time to prepare the document and the judge takes time to sign it, and that say takes 3 weeks, 4 weeks, then the clock still doesn't even start technically because you have to give the buyer a certified copy. And so I often, when I'm on the buyer's side, I want as much time as possible. I'm not going to tell the agent that, but that's what the title company will require to close escrow. And technically, that's what the seller needs to push the buyer to close. However, when I'm representing the estate, when I'm working with the attorney and I'm representing the estate trying to get the property closed, we want to rush things as fast as we can. So the second that order is signed by the judge, I'm getting a certified copy. Now, many attorneys have been trained over the years to ask to get these from the bond company. Back in the days, the bond company, back when pre-COVID, the bond companies were in court every single day. There are multiple bond representatives, and you can pick your favorite bond rep, and he'd go down and get you the document, and you'd have it the next day or next time you're in court, or they might deliver it to your office. But it doesn't happen the same way every day. The bond companies aren't there every single day in the same way. Sometimes attorneys will ask the title rep to do that. Again, same thing. The title reps are not in the court as often as they used to be. Nobody is. So when I'm the listing agent, I take that responsibility for my client. I make sure it gets done. I handle getting the court. Now, either I go to court myself or I use an attorney's service, no different than an attorney could do. The county charges $60 for the form. Somebody's got to go there and pick it up and then deliver it to the buyer or the escrow to get the clock to start. But the clock doesn't start until that document's delivered to the buyer or the buyer's agent. Very important. So if you want to get the best service possible for your clients or for your court confirmation sales, work with an expert who's experienced, knows the process, and will go the extra mile, and don't settle for 1980s service in the year 2022 and beyond. I'm Bill Gross, the LA Probate expert. Call me, text me, or email me if I can help you get the results you deserve.